Hello, my name is Professor Shiladitya Rakshit and I am recording this module on behalf of Professor Rohini Sen. The need to institutionalize the principles of prevention and prohibition of cruel, inhuman or degrading treatment as emphasized by the Convention on Refugees. Introduction. Article 5 of the United Nations Declaration of Human Rights states, "No one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment." In order to further institutionalize this principle and provide nations with specific protocols with regards to treatment of captured persons, refugees and other personal conventions have been passed. The Convention on the Status of Refugees entered into force on 26 April 1954 and it has been subject to only one amendment in the form of a 1967 protocol, which removed the geographic and temporal limits of the 1951 convention. The convention is both a status and a rights based instrument and is underpinned by a number of fundamental principles, most notably non-discrimination, non-penalization and non-refoulement. While the Convention Against Torture, which was enacted in 1984, protects all persons from torture and inhuman treatment, it does not deal with the atrocities against refugees, in particular two learning outcomes. To have a general idea of the international stand against torture and inhuman treatment, to understand the flaws that arise owing to a blanket law which is included differently in different national legislations, to understand the rights that international law offers to prevent torture. Rights of non-refoulement. The rights of non-refoulement is fundamental to the convention. It provides that no one shall expel or return a refugee against his will in any manner whatsoever to a territory where he or she fears threat to life or freedom. In 2001, state parties issued a declaration reaffirming their commitment to the 1951 Convention and the 1967 Protocol, and they recognized in particular that the core principles of non-refoulement is embedded in customary international law. Development of the principle. Prior to the 1930s, this principle did not exist at international law. In order to understand the principle, it will be useful to look at the circumstances and reasons surrounding its development. During the first half of this century, the idea that it was fundamentally wrong to return refugees to places where they would clearly be in danger was mentioned occasionally by states in agreements or statutes, or was evident in the practice of some states. Although by 1905 it had been enshrined in a UK statute that refugees with a fear of persecution for political or religious reasons should be allowed into the country. It was not until latter that the idea of non-refoulement of such people became widely accepted. It was first expressed at international law in the 1933 Convention relating to the status of refugees, which, however, was ratified by very few states. The massive refugee flows produced by the destructions of World War II provided an impetus for a thorough examination of the rules relating to refugees. Prior to this time, states had been very aware of the extent to which consent to rules, especially international rules relating to refugees, would impact on their sovereign right to determine who was allowed to reside within their boundaries. Although many appear to have accepted that there was a moral duty to accept refugees and not return them, this was done largely on an ad hoc basis. However, in the first few years of its creation, the United Nations showed its concern with the refugee issue. In 1946, the General Assembly passed a resolution stating that refugees should not be returned when they had valid objections. This concern, prompted largely by the huge number of refugees in Europe following the war, eventually led to the drafting of the United Nations Convention relating to the status of refugees, which was signed in 1951. 1951 Convention. The Convention itself deals with various aspects of law relating to refugees and remains the primary instrument of refugee law. It was intended to consolidate the various international laws and practices impacting on refugees and asylum seekers. It was also recognized that certain countries bore a much bigger burden than others with respect to the refugee flows. Therefore, it was imperative that an international approach to the problem be taken. The Convention defined who exactly was to be viewed as a refugee and spelled out what rights these people would have. In 1967, by way of a protocol, the Convention was amended and signatories were given the opportunity to remove the geographical and temporal restrictions present in original document. For our purposes, Article 33 of the Convention is of primary relevance. The first paragraph of this article states that no contracting state shall expel or return refouler, a refugee, in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group or political opinion. Although this was intended to be an absolute right, states remained concerned about the erosion of their sovereignty that this could create. Therefore, a second paragraph was tacked on, provided that the right of non-refoulement could not be claimed by someone who was seen as a risk to the security of the country or who had been convicted of a particularly serious crime. Since 1951, 137 states have signed the convention, thereby accepting the principle of non-refoulement expressed therein. However, problems have arisen regarding the interpretation of Article 33. Debate continues to surround the issue of whether or not a refugee must be inside the state. In order for the right to accrue to them, if so, then states would be perfectly within their rights to turn away asylum seekers at the borders or ships at sea. There was also discussion as to whether a refugee had to meet the strict requirements of the convention before they could be granted the right of non-refoulement. However, through the work of the United Nations High Commissioner on Refugees and general state practice, it has been accepted that Article 33 applies to all refugees whether or not they fit the prescribed definition. The 1951 Convention has been interpreted in the light of international law obligations arising out of other conventions and treaties, including the Convention on Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, the ICCPR, the CEDAW, the UDHR, the Draft Program of Action of the United Nations International Conference on Population and Development. Article 33 of the Convention refers to the prohibition of expulsion or return or refoulement. It reads, "No contracting state shall expel or return refouler, a refugee, in any manner whatsoever, to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group or political opinion." The benefit of the present provision may not, however, be claimed by a refugee whom there are reasonable grounds for regarding as a danger to the security of the country in which he is or who, having been convicted by a final judgment of a particularly serious crime, constitutes a danger to the community of that country. 4. Prevention of torture and the right of non-refoulement. In the light of the Convention on Torture, the refoulement obligation in Article 33 of the 1951 Convention has been subject to the broader obligation in Article 3 of the Convention on Torture not to return any person to state-sponsored torture. In Suresh versus Canada concerning a Sri Lankan refugee in Canada, the court clarified the interpretation of the Refugee Convention. Suresh was recognized as a refugee, but the Canadian authorities intended to deport him in spite of a risk of torture because of his involvement in an organization allegedly engaged in terrorist activity. The legal issue was the relationship between Article 3 of the Convention Against Torture (CAT), which prohibits deportation in all cases, and Article 33, Para 2 of the 1951 Convention, which provides for certain exceptions from the non-refoulement principle. The Supreme Court of Canada held, in our view, the prohibition in the ICCPR and the CAT on returning a refugee to face a risk of torture reflects the prevailing international norm. Article 33 of the Refugee Convention protects in a limited way refugees from threats to life and freedom from all sources. By contrast, the CAT protects everyone without derogation from state-sponsored torture. Moreover, the Refugee Convention itself expresses a profound concern for refugees, and its principal purpose is to assure refugees the widest possible exercise of fundamental rights. This negates the suggestions that the provisions of the Refugee Convention should be used to deny rights that other legal instruments make. 5. Prevention of torture and the rights against persecution under the Refugee Convention. Grounded in Article 14 of the Universal Declaration of Human Rights 1948, which recognizes the right of persons to seek asylum from persecution in other countries, the United Nations Convention relating to the status of refugees, adopted in 1951, is the centerpiece of international refugee protection today. Article 1 of the Convention refers to the right to seek asylum in order to avoid persecution in one's country. The emphasis of the definition of a refugee under Article 1 is on the protection of persons from political or other forms of persecution. A refugee, according to the Convention, is someone who is unable or unwilling to return to their country of origin, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. The risk of persecution is central to the refugee definition. The concept of persecution is central to the universal refugee definition laid down by the 1951 Geneva Convention (GC). Indeed, Article 1A GC defines the refugee as someone who has a well-founded fear of being persecuted. The Refugee Convention relies heavily on the concept of persecution, but it does not define it. It only gives us two direct indications. First, in order to qualify as a refugee a person must risk persecution for reasons of race, religion, nationality, membership of a particular social group and or political opinion. Otherwise stated, whatever literal meanings the word persecution may have. In other contexts, only persecution that is linked to one of these 5 grounds is relevant for the Convention. Secondly, as made clear by Article 33 GC, threats to life or freedom are readily included within the scope of the term persecution. It must be emphasized here that the converse is not true. Persecution cannot be defined as including only threats to life and freedoms. This view, expressed by Atle, Grahal, Madsen more than 40 years ago, has become canonical in literature and in international practice. Articles 31 and 33 refer to those whose life or freedom was or would be threatened. So clearly it includes the threat of death or the threat of torture or cruel, inhuman or degrading treatment or punishment. Therefore, the Refugee Convention, when read in the light of internal humanitarian law and the right against persecution, prevents torture and inhuman treatment of refugees by protecting them in the host state and providing security from the forceful return to their state. 6. Case study: Eritreans in Sudan and Egypt. Hundreds of Eritrean refugees have been enslaved in torture camps in Sudan and Egypt in the past 10 years, enduring weeks or months of violence and rape and extorted by traffickers, often in collusion with state security forces. Some of the refugees have died and many have been scarred for life, both physically and psychologically, as a result of mutilation, burning, beatings and sexual assault. According to dozens of testimonies collected by Human Rights Watch in a report published on Tuesday, victims were, within quotes, brutalized, including being whipped, beaten, deprived of food, raped, chained together and forced to do domestic or manual labor at smugglers' homes. Collusion between traffickers and Sudanese and Egyptian police and military is widespread, according to HRW, which says both countries are breaching their obligations under national and international anti-trafficking laws, international human rights law and national criminal law. Traffickers have kidnapped, tortured and killed refugees, most from Eritrea, in eastern Sudan and Egypt's Sinai Peninsula. Members of the UN Human Rights Council called on Egypt and Sudan on March 14, 2014 to investigate and prosecute traffickers for kidnapping, torturing and killing refugees in the Sinai Peninsula. The 24 countries sponsoring the German-led statement also called on both countries to identify and prosecute any security officials who may have colluded with traffickers. Egyptian officials have for years denied the horrific abuse of refugee going on under their noses in Sinai, unquote, said Jerry Simpson, senior refugee researcher for Human Rights Watch and author of the report. Within quotes, both Egypt and Sudan need to put an end to torture and extortion of Eritreans on their territory and to prosecute traffickers and any security officials colluding with them. The failure by both countries to adequately investigate and prosecute traffickers who severely abuse their victims and collusion by security officials breaches their obligation under the UN Convention against Torture, international human rights law, and in Egypt's case, national and international anti-trafficking laws. Human Rights Watch said an Eritrean refugee to New York Times said, "The torture is endless," thereby summing up the situation of the refugees. Summary: the module discussed the rights of refugees against cruel and inhuman treatment, while a separate convention on torture exists. The right to non-refoulement is discussed in the Convention on Refugees. The right, if non-refoulement, is the protection of refugees from forceful return to their home country. Their home country in most cases awaits them torture and inhuman treatment by one or more groups of persons. The rights against persecution is also covered under the convention. Thank you.